This is question 3 from the February 2024 California Bar Exam. If you value what we're doing here and you can support us, please head over to Patreon. That's patreon.com/barsecrets. For a very small fee, you can get access to our original, more detailed teaching lectures. We're adding subjects to that pretty much weekly. And there is a discount code good through the end of April to use on our website for 15% off any course, including Power Law. That code is Conquer July 2024. As usual, we look at the calls of the question first, but before we get there, a reminder, this is the third essay in a 3-hour block of time to do 3 essays, and it's vital that you keep yourself to 1 hour per essay. If you don't do that, when you get to this essay, you'll have less than an hour to complete it. And most frequently, the California Bar puts professional responsibility or some racehorse-like evidence in that third block to catch people who are not keeping to the timing. 1 hour, 1 essay. So as we look at the calls, it's immediately obvious that this is professional responsibility because it says answer according to California and ABA authorities, right at the bottom of the page. Pure professional responsibility. Notice that that instruction modifies all of the calls. Sometimes you'll see that instruction nested only under only one call, which would tell you that it's a crossover and that PR is one call in an essay involving an entirely other subject. But here, it modifies all 5 calls. So the whole essay is PR. Okay, there are 5 items or time points listed here. I'm going to look at the instruction before them. And it says, what ethical violations, if any, has Allison, a name, that's the attorney, committed with respect to? Right? That instruction, ethical violations, be careful. They really are asking you about violations. So it would be a mistake to headnote something and say, no problem here. They want violations. The first thing is season tickets to Davos's games. D name, that's probably a defendant. Payments to Wilfred, a W name, usually a witness. C, payment to Eileen. I don't know who that is, but it's an E name. It may be an expert. D is presentation of Eileen's expert opinion. So yes, Eileen is an expert. And E is Allison, the attorney's, statements in closing argument. Well, I don't want to read too much into the calls, but that last one about statements in closing argument, what comes to my mind right away is the main rule about fairness to opposing party and counsel. It has a section about what an attorney shall not do in closing arguments or to the trial court. So I wonder if this is a fact pattern centered around fairness to opposing party and counsel. We'll have to see as we read it. And we see that Allison is a criminal defense attorney. She represents Davos, a professional athlete. And they tell us a valid written retainer agreement. So I'm not going to form the relationship or do a whole lot about the entire law about fee agreements. Davos was charged with assaulting Karen at a restaurant. Allison asked Davos to gift her season tickets to Davos's games if she prevailed in the criminal case. Look at that if. If she prevailed. That is a contingency. It's a contingent fee. She can call it a gift all she wants, but she's asking her client for something in return for prevailing, only if she prevails. So I'm going to analyze that as a contingency fee. And the very most basic rule about contingency fees in criminal prosecutions is that they are not allowed, period. So, I need that basic rule. Would I talk about the fact that even if it had been allowed, this would not be a valid contingency fee because it needs to be in writing and it clearly is not, and go into all that detail? I could, if I have time. Is this a business transaction with the client? That's a bit of a stretch. It's season tickets to the team that he works for, so I suppose you could stretch it to that. I don't think you really needed that. What you really needed was that basic rule that you cannot have a contingency fee in a criminal defense case. That is call A, that request for season tickets. The rest of that paragraph says, at trial, the prosecution presented the restaurant's surveillance videotape as evidence, which showed the assault along with a video surveillance expert who identified Davos in the video. Allison presented the testimony of two witnesses. One, Wilfred, who was waiting tables at the restaurant and saw an argument between Davos and Karen but did not see an altercation. So this is a fact witness. This is a lay witness. And two, Eileen, an experienced video technician who testified that in her opinion there was no assault based on the poor quality of the video. So the first witness is the B call. The second witness is the C and D calls, the expert. When Allison and Eileen had previously watched the video together, they both agreed that the video showed strong evidence of the assault. You can see what's coming, can't you? She agreed that there was evidence of the assault. And then on the stand, she says, no, the video is too poor. So she looks like perjuring herself on the stand. And it looks like what is coming up is that Allison is paying her for the testimony that doesn't match her true expert opinion. Allison agreed to pay Wilfred an hourly fee roughly equal to the hourly wages and tips at the restaurant for his time in testifying. That's the lay witness. And for an entire day of preparation, but only if Wilfred refused to meet with the prosecution before trial. Okay, we need to talk about this, and I think we need to go over to Proponics and look at the law. So I think this is a much more complex call to analyze than was the first one. So this call about the payments to Wilfred, look at what we have here. We have an offer to pay, but only if Wilfred refused to meet with the prosecution before trial. Can an attorney do that? No, that's unfair to opposing counsel. You can't keep a witness away from the opposing counsel, here the prosecution. But knowing that overarching rule is not good enough to thoroughly analyze this call, because this call has an and in the payments. It has hourly wages and tips for his time in testifying, and it also has an entire day of preparation. We need to analyze all of that, but look at what this is all about so far. It's about fairness to opposing counsel. So let's go over to proponics and take a look at the law. So it looks like this hypothetical, or the most of it, is centered around fairness to opposing counsel. A lot of the California rule, the modern California rule, is the same as the ABA. It's rearranged somewhat, but there are parts that are different. So this is one of the areas where I would consider this to have major distinctions from the ABA model rules. I'm looking at the area of attorney as advocate, and I'm looking at candor to the opposing party or counsel. You could call that fairness to opposing party, same difference. And look at the parts here. Look at the detail that I'm going to focus on. An attorney shall not unlawfully obstruct access to evidence, including a witness, and that's what's happening here with Wilfred. She's trying to unlawfully obstruct access to evidence. Shall not suppress evidence legally obliged to reveal or produce. Shall not falsify evidence or counsel or assist a witness to testify falsely. It looks like that's what she's doing with the expert. Shall not directly or indirectly pay or offer to pay witness contingent on content of testimony or the outcome of the case. It looks like she's doing that with the expert as well. The attorney may advance or guarantee payment of expenses reasonably incurred by the witness in attending or testifying, reasonable compensation to a witness for loss of time in attending or testifying, and a reasonable fee for professional services of an expert witness. So that detail, it looks like, is tested here as well. Reasonable compensation to a witness for loss of time in attending or testifying. That rule I need for the payment to Wilfred. And it looks like I'm going to need the last one there, reasonable fee for professional services of an expert witness for the expert, the payment to the expert. But I also need the overarching rule that she shall not directly or indirectly pay or offer to pay witness contingent on content of testimony or outcome of case. It looks to me like the professor who wrote this hypothetical sat down with Rule 3.4 and developed a hypothetical that would pull at your detailed knowledge of this entire rule on fairness to opposing counsel. More often in the past few years, we see PR hypotheticals that do that. They take one complex rule, major rule, important rule, and just really go after the detail in it, in that hypothetical. So let's head back to the hypothetical and see what we have. Because the call asked for ethical violations, I'm going to start with the last phrase in that paragraph. The only if Wilfred refused to meet with the prosecution before trial. And I'm going to point out that that's a violation of the A part of that rule, that the attorney can't unlawfully obstruct another party's access to evidence, including a witness. And that rule goes on to say that the lawyer shall not counsel or assist another person to do any such act. That's what she's doing here. She's counseling Wilfred, not to be available for the prosecution. That's a violation. Now, what about the fee itself? Well, I'm going to tell the grader that although the hourly fee, roughly equal to his hourly wages and tips at the restaurant for his time testifying, looks reasonable, The question of paying a lay witness for an entire day of preparation is an open one that has not directly been decided by the rule, and as far as I know, not by the trial court, the bar's trial court. It looks like it would probably be reasonable, but that's an undetermined area. In any case, making it contingent on her not testifying, not being available for the prosecution, that makes the whole arrangement a violation. So now we go on to see that once Eileen agreed to change her opinion and testify that there was no assault based on the quality of the video, Allison agreed to pay Eileen $500 per hour for testifying at the trial. Okay, a lot packed in here. First off, the simplest thing is that that's a per se violation of the rule. You can't make payment contingent on the content of the testimony. But I also want to use the fact that she was paying her $500 an hour. So I think the way I would deal with that would be to quickly tell the grader that if the content of her testimony was not at issue, if she wasn't paying contingent on the content, that $500 would be okay if that's a reasonable rate for that kind of expert. It seems high. If it's much higher than an expert of that sort would ordinarily be paid for that kind of work, simply reviewing a videotape and giving an opinion about it, then that would also be a violation. But there's a very big issue in this call that I have to address, and that is that this attorney is assisting in a fraud before the court. She's assisting in perjury. She's encouraging this expert to perjure herself. That's misconduct of the worst sort. And I want to get all of that into my answer. This affects more than opposing counsel. This affects fairness to the tribunal as well. So Allison is really counseling someone to commit a crime, the crime of perjury. That's misconduct, and Allison technically is required to report herself to the state bar. Of course she's not going to. I'm waiting for them to test the snitch rule. It used to be that in California, attorneys were required to report their own violations, but not those of other attorneys. Now they're required to report others as well. But this, call C, is a big call. This is really an important one. I'm going to spend more time on that than on the earlier calls. What else does it say? It says, in her closing argument, Allison argued that the video showed that there was no assault and that in her own opinion, after considering the evidence, Davos was not guilty. Well, think back to what we looked at in proponics. So think about the last provision. A lawyer shall not, in trial, state a personal opinion as to the guilt or innocence of an accused. That's the ultimate job of the trier of fact, to determine the guilt or innocence of an accused. That is not an attorney's job. So an attorney may not state a personal opinion as to guilt or innocence at trial, and that's exactly what she's done here. She could tell the jury that after reviewing all of the evidence in the testimony, they should find her client not guilty, but she can't tell them it's her opinion that her client is not guilty. And, of course, she cannot suborn perjury and then tell the jury that because of the perjury they should find her client not guilty. So this tested so many provisions in that rule on fairness to opposing counsel. It also tested the overarching duty of an attorney to be honest And I would probably want to get that overarching concept across as well. In fact, pretty much every violation here stems from the fact that this attorney was dishonest from the get-go. And if I can tie everything together with that concept, that would make my answer more powerful.